session. We will start the medical legal session with the talk of Dr. Inderchand Rustagi. He will talk on medical legal aspects, ocular emergency. Please.
Good evening all. Thank you sir for providing me this opportunity. So my topic is my medical legal aspect of the ocular emergency or injury. There are few pictures of ocular emergency or injury. हर तस्वीर कुछ कहती है. Medical legal case is a case of injury or illness where the attending doctor, after eliciting history and examining the patient, thinks that some investigation by law enforcement agency is essential to establish and fix responsibility for the case in accordance with the law of the land. An MLC means that litigation against the accused, insurance claims, medical negligence claims and workers' compensation issues, they all come into play. So it becomes very much important. Victim of eye injury is presenting to eye hospital or a hospital is a medical legal issue unless until proved otherwise. So with medical management, proper documentation of injury be done as a legal duty by the doctor. And the documentation should be clear, detailed, accurate and objective. Thus it is imperative that we have a working knowledge of how to handle such cases to have the patient, to save the patient from harm and at the same time save ourselves from litigation or being caught on the wrong foot. This is a few instances of the medical legal cases like all injuries, and the most common cause of the medical legal injury which is presenting to an eye hospital is a fist injury. Injury can be accidental or inflicted ones. So accidental can be work related or may not be work related. If it is a work related, again the documentation and workup becomes very much necessary. And if it is inflicted ones, because they are inflicted ones, they are always associated with legal problems. And most of the cases they land up in the court or the criminal court. So you have to be very extra cautious. The injuries, as per classification, they can be open glove injury or closed glove injury and chemical injury. So on the job, eye injuries are a major cause of socio-economic damage, morbidity and disability. And that includes the direct cost of the medical care, indirect costs such as time of the work, loss of income, long-term disability and workman compensation claims. The implementation of the effective safety strategies beyond the use of the safety goggles that is usually there in an industry. So if we take some more extra cautious, and that can save from medical legal actions. Then comes the grievous injury. The eye being an important organ of senses, a significant trauma can result in the permanent deprivation of the eyesight. So grievous injury or hurt has been defined in section 320 of the IPC, that which is relevant to the ophthalmology concerned are either the permanent privation or the loss of the eyesight, permanent disfigurement of the head or the face, and any hurt which endangers life or which causes the sufferer to be during the space of 20 days in severe bodily pain or unable to follow his routine work. Medical legal report and expert opinion of the ophthalmologist always form the basis of the evidence. The ophthalmologist should be ready with the sight of the impact and the possibility of the internal injury, identification of the causing injury, cause of the injury, direction of the injury and time of the injury. That all has to be documented well, because he has to give the evidence in the court. And medical legal duties start right at the first clinical examination, and how the injury was sustained, giving clues to the penetrating forceful injury. It is vital to test always the visual acuity or IOP first. An MLC certificate should be carefully prepared in duplicate, taking a carbon copy, and mandatory to take note of the type, location, direction, dimension and presence of the foreign body in the wound, and measurement has to be very much almost accurate as far as possible, and if possible, because it is a digital erratic, the photograph. Be aware of the words while documenting or while communicating with the patient. Patients are very clever. They are always they can put the phone in the recording mode. So make sure they are very precise that it's something like that approximately. They should be avoided. Informed consent has to be taken, and consent should be from the patient if he is conscious. Or it is always important to restore the anatomy in case of injury. Achievement of the best visual acuity, that is important. Always have the better tools and the more knowledge, and you should attentive to determine the lesions, consolidation time and stabilization. The most important aspect is an injury that visual function and anatomy should be important issue. Ophthalmologist must have the skill to interpret trauma mechanism and correlate with the trauma they are seeing. So it is important for the ophthalmologist, especially practitioners, to be in the constant update in their knowledge and practice in whatever is new in order to make the best decision. In addition, they should know the applicable laws of the Indian judiciary system, and only then that could promote the proper management of the forensic cases. So usefulness of the MLC report lies in not only in the length but in substance, what is mentioned into that. And ophthalmologist has to give the proper records, and always have malingering in the mind whenever you document, because malingering is always towards the monetary compensation. So meticulous record is important thing, and standard protocol should be taken care of. In any medical legal, these are free precautions that the ophthalmologist should take, that female should not be examined in alone, operating theater should have all these things, and patient transfer is required, he has to be properly documented. And feedback always these days makes an impact in the medical legal cases. Patient's name should be there, and you should ensure proper reasonable skill and care in the treatment of the patient. You should sensitize your staff for triaging and effective counseling and update records, that is mandatory. And the most important thing is that always avoid criticizing your colleague. And these are the specific things, like you have to mention the corneal status, retinal status, vision, IOP, vision loss, and any intoxication, primary aid, and always try to classify the disease under OTS system. If needed, radiological imaging should be shot, photograph should be taken, and of course when to inform police you should know. Preventive steps should be taken in primary prevention, that is try to avoid the complaint filed. Secondary level, that if in any deficiencies there in document, you should avoid that. And tertiary level, that if there is any financial consequences, you should have a proper indemnity policies. So proper case management, effective patient communication, standardized medical care and clear documentation, they always remain the key to the avoid litigations. So claim that in the court of law, doctors saying that I didn't know, I didn't do that, so that will always take him in the that is not important in the court of law. And change of the professional negligence has economic, social and legal consequences. So doctor attending the ocular emergency should be well prepared. Thank you very much.
Thank you, Dr. Inderman, for the wonderful presentation.
Thank you, sir.
Now I request our chairman, Dr. A. Deshpande sir, for his presentation. Dr. A. Deshpande sir is ophthalmologist and lawyer practicing at Aurangabad, Maharashtra. He is chairperson of AIOS legal cell as well as Maharashtra cell. And he has been helping so many members in their medical legal litigations. Whenever the help is needed, he is helping a lot. whenever there was cluster endophthalmitis issue across the country, he is the person who has helped many of the ophthalmologists across the country. Via AIOS, he has helped many of them in the past. And he will be speaking about consent in ophthalmic practice. Over to you, Dr. Deshpande, sir.
The consent means to agree the same in the same sense. So whatever you are telling, the patient is agreeing to the same in the same sense. It is not taking otherwise also. Patient is not something understanding and you are telling something. So it should be valid only if given. So consent can be given for anybody, but it should be valid in the court, and for that purposes by an adult it should be given by a sound mind person. So he should not be certified as a mental person or mentally ill person, by a sound and mind person. In case of minor or unsound person, by guardian. In case if he is unsound or he is a minor, then the guardians will be giving the consent. The guardians may be parents or somebody else also. Before obtaining a consent, the patient should be informed about the nature of the condition he is suffering from. So first of thing, what from you are suffering, you have to tell the options of treatment available and what options are there, alternatives are available for your treatment, the advantages and disadvantages associated with the complications and the medical risk associated with each modality of treatment. And then you should say what are the disadvantages, what are the complications in each modality, that is alternative modalities also, and how you are giving the best treatment, you have to tell them. The written informed valid consent in patient's language, that is most important, because that should be in the patient's language so he can understand better, or he should understand. Better to take informed consent under the surveillance of the camera and recording of the voice. Nowadays it is very easy to take the consent on the surveillance, so he may not be able to say in the court that consent was not taken, I don't know where I have signed, he has said me to sign and I have signed. So better you have to record his signing, and also when you are talking. Keep the record of the consent as a hard copy of the consent from and a video of taking of the consent in soft copy, because all these things are required in the court, because you have to show that you have not done anything wrong with the patient. The types of the consent, as everybody know: free consent, valid consent, informed consent, express consent, implied consent. If appropriate consent is taken, doctor is saved from the criminal cases under section 304A. That is very important. From criminal cases he will be saved. Free and valid consent, when a patient is or his guardian gives his consent to the proposal given by the medical expert, he is deemed to have given consent. So whatever you are suggesting, they are accepting, that is the consent. It should not be under influence, mistake, fraud, coercing or misrepresentation. When a consent is given by a person who is of sound mind and competent to enter into the contract, such consent is considerable as valid consent. So that is should be there, it should be valid consent. The consent does not give total immunity from being held negligent. If you have given the consent, it doesn't mean that he has given the consent for doing the negligence by the doctor. So negligence is always different from the consent. So in consumer courts, the consent is not going to protect you, because the consumer case is based on negligence and not on the complication, and you are taking the consent of the procedure and complication. The patient signifies to undergo the risk of association with procedure for which the consent is obtained. If complications ensue or risk materialize due to the negligence of the surgeon, consent will not protect the doctor. So consent doesn't mean that doctor should do negligence with the patient. That just because the patient has given consent for an operation does not give total immunity from being held negligent. The consent indicates the readiness of the patient to undergo the operation with all ending risks. So whatever risks are there, they are covered, but negligence is never covered. a valid consent not only protects the doctor from civil liability but also criminal liability, section 87 and IPC code. So in emergency cases, when the surgeon comes to the conclusion that an urgent operation is required, but the patient is not willing to consent for the same, then it is advisable to obtain a written statement from the patient that they are not ready for the operation and they will not give the consent to the operation. If it should be duly attested by him and his relatives or attendants, preferably under the surveillance of the camera, because this is very important. At that stage they are not ready for giving the consent, but afterwards they blame, and this is the decision given by the Supreme Court and National Forum, that the consent should not be in form, that is printed form, but printed form particularly for AIOS. We have published a booklet in which what type of consent should be taken for particular operation. For each and every operation, consent is there in AIOS booklet. So just print out that and fill the gaps there. That is accepted in the court, but the consent form which are there for general surgery, gynec, operation, ENT, and that is not accepted by the court. Thank you very much.
Thank you, sir. You have wonderfully covered everything about the consent. And
Yes.
Sir, I want to know that whether if I am going to take a consent, so should be consent be written in the handwritten or it should be printed?
That's why I showed you the decision of the Supreme Court. That can be in the type of form, but particular consent should be for particular disease or operation, and only you are putting the names and other things and not other remaining things. Remaining things are already printed there because you cannot write that much by hand. And on the lower side, if there, I know, I have read the complaint in my language and I understood and signature, that is the best thing. We will have a discussion
Afterwards.
after the all lectures.
thank you, sir. Now I invite Dr. Manoj Chandra Mathur, who will be speaking about importance of indemnity insurance in ophthalmic practice, considering consent. Dr. Manoj Chandra Mathur is from the state of Telangana, practicing in Hyderabad. He is also medical legal consultant, helping many more ophthalmologists across the country and giving talks at various conferences. He is glaucoma consultant. Over to you, Dr. Manoj Chandra Mathur, sir.
Thank you, Dr. Marathe. And, good afternoon, everybody. Dr. Deshpande just spoke about the consent, how important it is, how valid it is. Despite a very valid consent, the court can definitely find an alibi. As he said, a valid consent may protect you from criminal negligence, but the court will certainly go into the merits of the case, considering the negligence aspect of the case of the patient, that the patient complains against you. So there are many ways to actually find an alibi to declare inadequate consent and compensate the patient. We also need to consider the temptation of the insurance companies nowadays to suggest mediation as per the new CPA Act. So based on this background relating to a valid consent, what should be our thing from our side, how to protect ourselves is the key question, and that is through the indemnity insurance. What is indemnity insurance? It is compensation for damages or loss in the legal sense, and it may also refer to an exemption from liability of damages. The concept of indemnity is based on a contractual agreement made between two parties in which one party agrees to pay for the potential losses or damages caused by the other part. So, doctors are professionals who face the risk of a financial liability. In the course of practicing their profession, the amount they can be sued can be really exorbitant, as we see these days. The doctors therefore require a special insurance so that they can protect themselves financially and legally when they are sued for negligence. The hospital has a vicarious liability for the whole staff, nurses, doctors, anesthetists, and surgeons. It does not matter whether they are permanent, temporary resident, or even visiting doctors, full-time or part-time. So if you are running a hospital, it is very important that you are required employ qualified doctors and nurses and get them covered. Their name should be included in the indemnity policy that you take for your hospital. But in solo practice, it is his or her responsibility, as he is the owner of the hospital, though it becomes less if a standby anesthetist is there. But in corporate trust and government hospitals, as I said, it is the hospital responsibility, it is a vicarious responsibility of the hospital, even for a surgeon visiting the hospital and operating in their setup. So even the name of the visiting consultant with the paramedical staff should be included in the indemnity policy that a hospital takes. So the range under professional indemnity policy provides for the extent of financial damage or loss caused to the victim against unintentional errors and omissions by the doctor. Also, insured qualified and non-qualified employees and staff, as the policy does not cover for criminal acts. Whatever policy you take, the policy doesn't cover for criminal act, and the cost of defending oneself in the court of law is covered, and the plan covers for 1 year. So the compensation from insurance policy, the policy will pay the sum assured that has been set as a limit. The expense over and above the sum assured has to be borne by the doctor. Here the sum insured is referred to as a limit of indemnity, and this limit is fixed per accident and per policy period. So there are various indemnity policies. What are the options before us? From where should you take your indemnity policy? So there are three basic options. One is you can take your indemnity insurance through medical legal consulting services organizations, or you can take from the professional protection scheme of the IMA, or you can take it individually from the professional indemnity policies provided by the national general insurance companies. The advantage if you take an indemnity policy through a medical legal consulting services organizations is they give the support in consumer litigation. They give insurance like you take from a nationalized company, like National Insurance Company, Oriental or United India Assurance Company. The guidance is given in maintaining the medical legal record. This is important, and advice, inspection of documents, preparation of documents, advisory support and advocate support will be given in stages of the consumer cases in all consumer courts and even in Supreme Court. Coming to the IMA policies, the aim is again the similar aim, and the eligibility is only for the life members of the IMA. And here the scheme is liable to pay the member maximum of rupees 5 lakhs. They have units of 3,000. A non-refundable membership fee of 3,000 rupees per annum needs to be paid for a cover of rupees 5 lakhs. And you can take additional number of units. If you take 9,000, you are covered for 15 lakhs, something like that. Subsequently, if there is a no claim, subsequently the membership fee reduces by 100 till you reach a stage of 2,500. And once a claim occurs, again you need to start back with 3,000 rupees per policy, per unit. And here the concerned member shall, the moment you get a notice, you need to inform the state representative of the scheme, and the concerned member will obey the instructions of the IMA management and should agree to their terms, and they will be giving you all the support, and you can fight out the case in the court of law. And should the IMA at a later stage advise you to file a counter claim for compensation from the patient in case of false claims by the patient proved in the court of law, in such cases the clause is that if you win a counter claim, 50% of it goes to the IMA. Now, coming to the third important part, if you want to take your own indemnity policies, what are the important things that you should know? That is, the insured policy includes the policy holding and his qualified assistants and employees. As I told you, you should include your assisting staff, and the policies are available for individuals, hospitals, as well as for diagnostic centers. The note and caution is short-term policies are not permitted. You have to take it on a continual basis. All claims have to be legally established. However, the company can offer an out-of-court settlement which should be accepted by the claimant. The jurisdiction is all Indian courts, and there is a group discount for over 200 members. And the calculation of premium depends on two factors. You should know this. One is AOA, any one accident. that is limit 23.5%, 33% or 50%. These are the things that you should read between the lines. If you take a policy, if say for example 1 crore, and if the policy, if there is a claim for say 75 lakhs, but your policy states that it is 25%, that means per incident you are eligible only for 25 lakhs and not for the 75 lakhs claim that the case is sought for. So it is very important that you take your policy with 100%. Any one accident means 100%. That means whatever insurance claim the cover you take is valid for even one case. The premium for this is slightly high, but you need to take such a policy in order to, like why it happens is one insurance agent may come and say, I give you cover for 16,000 rupees for a crore cover. Another agent may come and say, I give you for 8,000. You will be tempted to take the claim from 8,000, but in between the lines, it will be written that AOA is 25% or AOA is 33%. That means for one particular case, you will be entitled to only for 25 lakhs or 33 lakhs as the case may be. So it is important that you take the policy cover for 100%, that is AOA should be 100%, so that whatever cover you take is applicable for any claim amount. The most important clause to be understood, the act has to be committed during the period of insurance commencing from the retroactive date and continued thereafter a break. So the take home message from this talk is, for professional indemnity, there is no grace period and the policy should be mandatorily renewed before each date. Like in endowment policies, you have a grace period of 1 month. Even if you overshoot a policy date, you get a grace time of 1 month to pay up your policy and keep it updated. But for indemnity insurance, you have to pay before the due date. Otherwise, if you pay even 2 days after the due date, the retroactive date changes to the day you have taken the policy. Whereas legally, the patient can file a claim within 2 years of the date of incident. So since there is a break in the policy, you will not be entitled to compensation. This is the thing. So the two important thing is, always take your policy with a AOA any 1 year of 100%, and then also keep in mind that you need to renew your policy before the due date to keep your policy in continuation, maintaining the retroactive date, so that even if there is no break in the policy, only then you will be entitled for insurance claim. Otherwise, the insurance company will conveniently deny the compensation to you. So thank you very much for your patient hearing.
Thank you, Dr. Bathur, for giving a explanation about the insurance and how one can get rid of the court orders. Now I will request Dr. Prakash Marathe he will be talking on common mistakes in taking, because we have said how the consent should be taken, what consent should be taken and everything, but still we do the mistakes, and the mistakes are going to affect the judgment of the court. He is going to speak about that. He is a past president of Maharashtra, and he is also in IMA, a very vice president of the IMA, and he is also contesting the AIOS elections.
Thank you, sir, for the opportunity. The topic allotted is about common mistakes in taking consent in ophthalmic practice affecting judgments. I think consent is the important thing. Few things like when it is to be taken, how it is taken, and why it is taken. So when it is very important, some people say it was taken so early that we were not prepared. And some people say that it is taken so late that just half an hour before the operation. In that case, we can give that consent form to the patient and relatives when the patient comes to finalize the date. Ask the patient to come with the consent, and at the time of surgery also, just before the surgery, you can take one more signature. So it is not that late and it is not that early. So both the options are covered. How it is taken? So proper signature with witness, and what sir has said, that it is not the blank consent. Like proper procedure related consents are prepared by AIOS in local languages also, like Marathi, Bengali. Those consents definitely can use. Why it is taken? Because for medical legal litigations are to be avoided. So necessity of the procedure, you must explain to the patient and relatives. You must tell them what are the alternatives available and what is the end result of your procedure. Suppose it is enucleation or evisceration. After the procedure, patient is not able to see. But then after few months or few years, when some relatives tell him, he comes to you, doctor, the operation is done, but I cannot see. But if you have explained the patient beforehand why the evisceration and enucleation was done, probably visual gain is not expected by patient and relatives, then the cost of that particular surgery in case of IOLs and all that, there should be transparency in your communication. So comparative costs must be told to the patient what type of surgery you are doing, what type of IOL you are putting, and what are the charges. So that transparency definitely helps you. That is one important thing you must remember: promise less and deliver more. Most of the times patients are being told that after the surgery, within 5-10 minutes you will be able to drive your own car and go home. See, these fantasy like things you shouldn't promise. So promise less, but if the delivery is a little more, patients are more happy. So branded is costing more, that's the thing people remember. Suppose Nike shoes are there, those are costing more as compared to routine shoe. So that way, if the branding of that IOL is international, probably they will pay you more. Then general and non-branded, they are costing less. So in that particular sense, they understand and then remember. About guarded prognosis, I have said enucleation, evisceration. About the gain of the vision, if you have told everything properly to the patient and relatives, they will accept. About fantasy, I have explained just now. Multifocals, you have to assess the patient properly, whether that particular patient is capable of handling all those little bit complications or side effects of multifocals if they are there. And cosmetic appearance is also very important after the end of the surgery and at the time of follow-up. Even if the visual gain is good, cosmetic appearance, the patients and relatives, they are worried about. So for counseling, it has to be done in front of patient, family and relatives. Suppose you are doing counseling only in front of patient, afterwards the family members and relatives may say that they were not explained everything. So it is better to involve few of them at the time of counseling and taking the consent. So counseling can be done, consent can be done in question answer session format. Ready modules are available. You can give them printed booklets like glaucoma booklet, cataract booklet, squint booklet, IL booklet. You can put those things, explanatory thing about that procedure on websites. Even videos can be shown to the patients and relatives what type of surgery you are going to do. Recording of that particular consent, if it's done, basically, if it is quite safe for you and your hospital. Documentation is the thing which saves you in the court of law. So documentation is must. Whatever is documented is done. Whatever is not documented is not done. So even if you have done good thing and not documented, well, it is not accepted in the court of law. So be careful. If it is CCTV recording, you have done in a proper way, probably it also saves you in court of law. And from medical legal litigations, you are saved. This thing about the consent, Dr. Deshpande sir has already covered. So I am not going to into details like competent person, major and guardian. In case of child, 7 to 12 years, it is the gray area. 2 witnesses are must. It must be simple, any language, patient's language, that must be specific, clear, unambiguous. Mention common complications and alternatives. Don't hesitate to tell complications to the patients and relatives. In emergency like situation also, don't prohibit from taking consent. In case of evisceration and enucleation, it is must to have second opinion, and the second doctor must be patient's and relative choice, not of your own choice. So about details of consent, written consent, implied consent, Dr. Deshpande sir has already explained about this. Doctor should not feel shy of informing and taking written statement. Even if there is refusal, sometimes patients and relatives, they refuse about the consent. Again, you have to boldly document the non-compliance of any of your advice. You can write that this advice was given to the patient and relatives and they haven't accepted, and take patient's signature on that particular document. In case of refusal, don't proceed for the procedure. You may postpone the surgery or you may cancel the surgery if the consent is not given by the patients and relatives. So consent of a child after 7 years, sometimes it is 12 years is a must along with guardians. So guardian must sign. So there is no such law as consent is a must, but MCI has given the guidelines. Implied consent can be constructed by the history. However, judgments from SC and National Consumer Forum stress the need of the consent. So I think with these words about Samira Kohli and Prabha Manchanda is the case which was reported in the court of law. The judgment in Samira Kohli's case held that doctors who performed a hysterectomy and bilateral salpingo-oophorectomy under anesthesia were liable after the patient's mother had consented. But patient was not knowing. Afterwards, patient said, I was under anesthesia. Why you have removed my ovaries? So the patient claimed the operation was not life-saving and consented to diagnostic laparoscopy only. So in that case, the hospital and doctor was punished. So blank and printed about general consents, Deshpande sir has already explained. On your consent, date is a must and it must be case and procedure specific.
Say I am a professor in a medical college. In my unit, there are 4 doctors.
Yeah.
The patient is coming and registered under unit 1. And any of the doctor does the surgery. May not be doing the preoperative or postoperative. If the person is going to court and compensation is claimed for the blindness, who will be at fault? The unit head or the surgeon who is only doing the surgery?
The thing is that whenever in a institute or in a government medical college or a government private medical college, whatsoever it may be, institute, I am to say, there is a Supreme Court decision and a National Forum decision also. There, the patient comes on the name of the institute and not on the name of the doctor. So the institute is collecting the money, and so the patient becomes the consumer of that institute and not of the doctor. Doctor is paid by the institute, so the doctor is giving his services to the institute. So directly the consumer case cannot be put on the doctor who is working in such an institute, first thing. So with these 2 decisions, he can be safely taken out and the decision case goes on the institute. Secondly, as such, in criminal cases, it is not so. In criminal case, whosoever doctor does the operation is the responsible and not the unit head or the dean or the institute. But in consumer cases, definitely institute, head of the department, and the medical college itself is the responsible and not the doctor. But the advocate should represent and bring to the notice of the court that this is the Supreme Court decision. Then only they take the case laws and give the decisions.
Okay, we will discuss afterwards. Just one more talk. We'll finish this.
Yeah.
So on behalf of Dr. Pankaj Varshney, I am presenting this. This is very important talk. Supreme Court of India, there was one case related to consent. So Samira Kohli versus Dr. Prabha Manchanda, that was on 16th of January 2008. So facts, Samira Kohli, the appellant, unmarried 44-year woman visited Dr. Prabha Manchanda, the respondent, on 9/5/1995 for prolonged menstrual bleeding. The respondent advised laparoscopy test under general anesthesia on 10th May 95. The consent form for surgery stated, this is very important sentence, diagnostic and operative laparoscopy and laparotomy may be needed. The appellant was under GA for laparoscopic examination. The respondent found that the appellant was suffering from endometriosis. Look at this situation. While the appellant was unconscious under the effect of GA, Dr. Lata Rangan, the respondent's assistant, took the consent to Suma Kohli. Who was Suma Kohli? The appellant's mother, to perform hysterectomy under general anesthesia for her daughter and bilateral salpingo-oophorectomy. So patient is unconscious. Patient's mother is asked for consent at the time of surgery, at the time of procedure. So the complaint was on 15th May 95. The respondent lodged a police complaint that a friend of the appellant visited the clinic on 15th May 95, abused and threatened the respondent, and got the appellant discharged without clearing the will. On 19 January 96, the appellant lodged a complaint before the National Commission claiming compensation of rupees 25 lakhs, alleging negligence for performing hysterectomy and bilateral salpingo-oophorectomy without her consent. So doing any procedure without consent was the blame. What were the issues? Is informed consent necessary for surgical procedures? Was there consent by Samira Kohli for the surgery to be performed by Dr. Prabha Manchanda? Whether the surgical procedures such as abdominal hysterectomy and bilateral salpingo-oophorectomy can be performed without a patient's consent under the principle of necessity. See, the necessity word is very important. Sometimes if the procedure is life-saving, that is different. This procedure was not life-saving. So whether Dr. Prabha Manchanda is guilty of any tortious acts such as assault or battery and be liable to pay damages to Samira Kohli. Whether the acts of Dr. Prabha amount to deficiency in service amounting to negligence, these were the questions raised. The case substantially depends on the issue of consent. Consent is an essential part of any medical procedure and is required before any procedure on an individual. If there was informed consent and then the surgery by Dr. Prabha Manchanda will be unlawful, thus it might attract liability under tortious act of negligence or assault and battery. In the present case, the appellant gave signature on the consent form for surgery, which stated that she was to undergo diagnostic and operative laparoscopy. It was also stated that laparotomy may be needed. There was express consent by the appellant for the performance of laparoscopy and laparotomy if needed. There was no mention of any abdominal hysterectomy and bilateral salpingo-oophorectomy on any of the three forms that she signed. Analysis 2. Furthermore, the consent obtained from the mother cannot be considered valid, as the appellant was a competent adult and had the ability to consent, and there was no medical emergency, and surgery made her infertile. Thus, in the absence of any express consent, the only unlawful justification for such a surgery by Dr. Prabha would be under the principle of necessity. This principle prevents doctor from performing any additional medical procedure on an individual unless the life of the patient, see, this word is very important, life of the patient is under imminent threat. So what are the references? These are the references. I need not read them. But what court observed, in the present case, even if the appellant was suffering from endometriosis, there was no immediate threat, and it was necessary for the respondent to take the appellant's consent, which was not taken in this case. Mother's consent was taken, and when the patient was under the effect of anesthesia. In the absence of consent, the act of the respondent would amount to assault and battery that attracts tortious liability. In Vinita Ashok versus Lakshmi Hospital, the Supreme Court of India had accepted Bolam test and stated that, this sentence is very important, a doctor cannot be negligent if he proves his treatment and opinion is reasonable or responsible. So the decision was, according to expert medical opinion, according to Bolam test and prior judgments of the court, in this case abdominal hysterectomy and bilateral salpingo-oophorectomy is not improper, unreasonable or irresponsible. Thus, even though the respondent will be guilty of assault and battery, she will not be guilty of negligence. See, this is different. But what the second para says, the Honorable Supreme Court held the respondent guilty of assault and battery amounting to deficiency in service and awarded rupees 25,000 as compensation. That was in the year 1996. 25,000 as compensation for the unauthorized surgery to the appellant and exempted the respondent from receiving any fee for the surgery. So, what is the take-home message? Whatever is the consent given, do that procedure unless it is life-saving. Don't try to act any additional surgery, any additional treatment on that patient, even if you feel it is all right. Thank you, sir. Thank you so much.
So we can go ahead with the questions now.
Yeah.
Sir, actually, what happens mostly in medical colleges,
Yeah.
it's a group which treats. Somebody comes on Monday and goes to
Yeah, according to the units.
and
Yeah.
tomorrow
Yes, yes,
the
yes,
other
I know.
somebody is
Yeah, I know.
and the patient having some problem goes to court for compensation, that I am seeing less or I am a one-eyed patient, I lost condition and who will be the liable person?
The thing is that, according to I said, the Supreme Court decision and the National Forum decision, both are saying that whenever a person is operating or visiting a hospital, trust, private, or a government or semi-government or a medical college or any other institute where he is being having the share of his fees or he is paid for that, he is not the consumer, patient is not the consumer of